All right. Good morning, everyone. This is Judge McBurney. We have a civil default calendar with now 5 positions on it. One was continued. And we're going to start with Golden Bee Enterprises. Is Mr. Bushnell on?
Yes, sir. I'm in a courthouse, and I'm sorry if there's some feedback. I'm trying to do this through my AirPods, and it doesn't seem to want to do it. Can you court hear me?
Yes, sir. I can hear you. Do we have anyone on the call or in court who is here for Golden Bee Enterprise?
I can't get the volume to work.
Mr. Lee, you are here for what case? Nathan Lee, what case are you here for? I'm going to mute you then. So anyone here for Recession Proof Partners or Donald Jacobs? No? We have I think a court reporter. I'm not sure, Mr. Bushnell, if you are paying for a court reporter, that's a different matter.
Correct.
Okay. You have the court reporter, and you're here for what case?
LGE Community Credit Union versus Health Style LLC and
Got it. All right, then I'm going to mute the court reporter until we need that person. And I think, Mr. Bushnell, we should be good to go. Let me call your case up on my screen.
And my client is Ashley Huntley. She's on the Zoom.
Oh, great. Let's do that. Whoops. There she is.
Yeah.
All right.
Keep messing with it. I'm gonna try to get on here. Where's the note?
So there's a conference room and it's labeled Nathan Lee. Who's sitting in that conference room? Because that person keeps turning on. I certainly want to include him. I'm gonna put you on the screen. Hey, people who are looking down at their table, gray suit, striped suit with a blue tie. Oh, you're muted. Okay, we'll hear from you later. The fun of Zoom. All right, Mr. Bushnell, my understanding is that you've got a default judgment against both Recession Proof Partners. That was entered because they were part of an answer filed by Mr. Jacobs. He is not a lawyer, so they had no counsel. They were given an opportunity to retain counsel. They didn't, so I entered an order effectively striking their answer. I'm not sure that they technically did answer, and entering a default judgment as to liability. And we're here to talk about damages. And much more recently, I did the same for Mr. Jacobs because of his persistent and consistent unwillingness and willful decision not to participate in discovery. And so he did answer. His pro se answer was for Mr. Jacobs and Recession Proof Partners. But he had his answer struck and default judgment was entered against him. And so we need to talk about damages.
Yes, sir. Can you hear me?
I can. And so
I actually figured it out.
Yep. If I pull up your all right, your complaint.
And I submitted my exhibits, which hopefully you have.
Oh yeah, I know I have those. Why don't we just work through those? So why don't you take it from here? I'm ready to listen to damages.
All right. Ms. Huntley, please stay open. Raise your right hand, please. Solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Okay. State your name for the record, please.
Ashley Huntley.
And Ms. Huntley, are you the owner of Golden Bee Enterprise LLC?
Yes.
All right. And did you enter into a series of contracts with the defendant, Recession Proof Partners, and Mr. Donald Jacobs?
Yes.
And is Recession Proof owned by Donald Jacobs?
Yes.
Would you state briefly for the judge how you met Mr. Jacobs?
We met out. I was at a dinner. He was at a dinner.
parties were kind of close together, and he sparked up conversation about real estate and kind of asking what I did for a living and if I was interested in real estate. And that led to him telling me about his business that he owned about mentoring people in the real estate space.
Right. And so did he wish to enter into a bunch of agreements with you regarding some real estate investments and flipping?
Yes,
All right. And did you enter into a total of 4 contracts with him?
yes,
All right. And was it 1 partnership and 3 contracts where you're supposed to be purchasing properties?
correct.
All right. And Your Honor, it'll go quicker if I don't have to share my screen, but I'm happy to share my screen. My client has the exhibits and you have the exhibits.
I don't think you need to share your screen. I'm good.
Okay. All right. All right. Plaintiff's exhibits A through D, are those the contracts that you entered into with the defendants in this case?
Yes,
All right. And one of these was a joint partnership agreement, and the other 3, you were supposed to be purchasing properties. Is that correct?
that's correct.
All right. And 4 of these were properties in Columbus, Georgia. Is that correct?
Yes,
And then later on, you entered into a more informal agreement with regard to a property in Dunwoody and Hammond Drive. Is that correct?
yes,
All right. Pursuant to the terms of the contract, you paid the defendant $18,000 for the Patch Drive property. Is that correct?
correct,
And you paid the defendant $12,000 for the Bruce property. Is that correct?
correct, as a down payment, yes,
And you paid the defendant $12,000 for the 48 Douglas property. Is that correct?
correct, as a down payment,
All right. And then you paid the defendant $40,000 toward the 621 Hammond Drive property. Is that correct?
that's correct. And those funds were later allocated towards the purchase of the Columbus properties.
Okay. And in exhibits E, F, and G, those were the proofs of all of the payments that you made to Mr. Jacobs and to Recession Proof Partners. Is that correct?
Correct,
All right. And again, some of these payments were to Recession Proofer and some were directly to Mr. Jacobs. Is that correct?
that's correct,
All right. And as part of these sales agreements, you were supposed to get deeds to the Patch, Bruce, and Douglas properties. Is that correct?
correct.
Did he ever transfer those properties to Golden Bee?
No, he did not.
And did you confront him about it repeatedly?
I did. I asked him about, again, the deliverables of our contract, and we would meet up in person to have discussions, and eventually he agreed to just send me the money back for everything, all of our transactions, because he did not make good on the deliverables.
All right. And did he in fact refund some of the money to you?
Yes,
Okay. Did he give you $9,000 back on 2020 on 2244 Simmons?
correct.
And did he give you $12,000 back on 48 Douglas?
Yes,
And did you repeatedly ask for the refund?
I did.
And did he repeatedly tell you he was going to pay you back?
Yeah, he strung me along for a while, almost a year, until I eventually just contacted an attorney to handle it civilly. And that's when our communication stopped.
And by your calculations, does he owe you $73,000? Is that correct?
Correct.
And that's not without any interest or anything. That's just the remainder of what
No
you paid him.
interest. That is every dollar that I sent him for these transactions.
Did you find out after getting involved with him and not getting paid back that Mr. Jacobs was a flim flam man?
If that's what you mean by a fraud, yes.
Okay. What did you find out about him?
I found out just meeting other people that he had done this to other women. It seems that he kind of target women and prey on them and try to get them to invest in real estate with no intentions on making good on these contracts or deals that he pulled people into.
And did you find out later on that one of the properties that was supposed to be transferred to you, he transferred to an LLC called Polished Doors?
Yes,
All right. And Exhibit H, is that the documentation that you dug up regarding Polished Doors
yes,
and that transfer? And Mr. Jacobs owns Polished Doors. Is that correct?
correct.
All right. And did Mr. Jacobs fraudulently induce you to enter into these deals by saying he would transfer these properties into your company's names?
Yes,
Would you have entered into these contracts if he hadn't told you he was going to put these things in your company's name?
absolutely not.
All right. And Exhibit I, is that the accounting showing how he owes you the $73,000?
Yes,
All right. And are you asking for damages in the amount of $73,000 for breach of contract?
yes,
And do you believe that he has committed fraud in this action?
yes, he has.
And are you asking for damages in the amount of $73,000 for fraud?
Yes,
All right. And did you have to hire me to handle this case for you?
yes,
All right. And Your Honor, I'll state in my place, and I have a separate exhibit that I will email to the court. I'm sorry, I had problems last night when I was creating it. But I will state in my place that she has incurred $6,030 in attorney's fees and expenses in the amount of $686.50. I do have a detailed bill that I will submit to the court as soon as I'm done with court today. That will be Exhibit J. I will state in my place that I'm an attorney licensed to practice law in the state of Georgia and have been so for 35 years. He's being charged a rate of $300 an hour, and that we believe that 13611 attorney's fees are appropriate in this case due to the unreasonable defense and the actions of the defendant and having to cause this litigation to begin with.
All right. Did you ever reach out to Mr. Jacobs, Mr. Bushnell? I know you filed the lawsuit, but before you filed it, was there a letter sent to Recession Proof Partners saying, "Hey, let's make this easy. Return the money to Golden Bee, and you go your way, and they'll go their way"?
I believe her previous counsel did that through the Deming Parker law firm.
Okay.
There was no response.
Okay. So there was a change in representation.
kind of, I went through Legal Shield and they introduced me to one attorney, and then one attorney said if it has to go through litigation, it will have to be handled by a certain type of lawyer, I guess, because of the amount. So yeah,
Okay.
there was a change.
Okay. Got it. All right. So, Mr. Bushnell, you'll get that information to Ms. Niles, Exhibit J, or whatever letter you used. And that will
Proposed order.
Yep, that'll shore up the attorney's fees. And then if you'll submit a proposed order that includes language for post-judgment interest and all that kind of stuff, I think we are all set. Anything else from you?
No, sir. I appreciate you. I'll get that to you tomorrow.
Okay.
I'm in court the rest of the day.
Yeah, no, I know you've got places to go. I'm curious. Is this the first time, ma'am, that you've gotten involved in, Ms. Huntley, in investments like this?
It is. It was a very lapse in judgment, and on my end, just being eager to invest and do things, and obviously trusting someone who I thought was a mentor or had years of experience in this space and wanted to kind of show me the ropes, and that really wasn't the case.
Okay. And what's the origin of the name Golden Bee Enterprise?
It's named after my daughter. Her name is Golden. So
Excellent. All right. Well, keep the name, get into a different line of investment, not with someone like Mr. Jacobs. Lesson learned. I'll get that order in, and then Mr. Bushnell can counsel you on how judgments are collected. Hopefully he's told you that it's actually not a check. It's not a check from the government saying, "I'm so sorry this happened. Here's all this money," but it is certainly a ticket that can be used to pursue Mr. Jacobs and his company. And there are lots of different ways to go after that. And you'll get help doing that. Okay.
thank you. I appreciate it.
You bet. Thank you, Mr. Bushnell. Good luck with the rest of your day.
Thank you. Bye-bye.
Bye.
All right. Next up is Northwest Georgia Paving versus Deep South Grading and J.W. Wilson. Who do we have on for that?
Your Honor, Mitchell Snyder with the minor firm in Dalton, Georgia, and I represent Northwest Georgia Paving Incorporated.
All right.
Good morning, Your Honor. My name is Nathan Lee. I represent I represent the owner is T. Cooper James, but their entity in this is
Plainville.
Plainville DG, Your Honor.
Yep. Okay. Excellent. Anyone on for Deep South or J. Wilson? Nope. Okay. So Mr. Snyder, nope. Hold on one second. Okay. Remind me how Deep South sought to open default. Was there a lawyer briefly in the mix?
There was, Your Honor, who filed the motion to open default for Deep South and filed an answer for J.W. Wilson, and Your Honor denied the motion to open default and granted that counsel's request to withdraw from representation.
Okay. I noticed there are a couple notices of deposition that were recently filed in the docket. Is that because there is still litigation ongoing between Northwest Georgia Paving and Plainville DG?
Yes, Your Honor.
Yes, Your Honor, as well as litigation between J.W. Wilson. The court granted permission for him to be added late. So he was not in default so the default judgment issued today is only against Northwest Georgia Paving and Deep South Grading. There will be litigation after today continuing.
Okay. And if I'm remembering from way back when, maybe are there cross claims? Is Plainville also saying, wait a minute, J.W. Wilson and Deep South?
We have, Your Honor.
Okay. All right. So that stuff will keep going. Well, then let's hear about the default against Deep South.
And Your Honor, there is a verified complaint filed. So my client has provided, I guess, sworn statements regarding that. I hope that's sufficient for the liquidated amounts. I'm prepared to testify about the unliquidated amounts of attorney's fees today. But what this matter involves is grading and paving and site preparation work for a Dollar General site in Plainville. And what there are invoices that were attached. We were hired by Deep South Grading and Construction to come in and to perform this work. There are proposals that were signed by the individual J.W. Wilson to perform the work, which are attached to the verified complaint as well as the motion. Those invoices total $346,473.56. And we are asking for judgment in that amount as well as interest. This is a commercial account, and so we have alleged in the verified complaint and asked for interest at the rate of 1.5% per month pursuant to OCGA 7-4-16.
Did you say 2.5 or 1.5?
1.5.
Okay. That's what it says in the complaint. Keep going, but only on a smaller portion of the 346,000. Still a big number, but a little less than 310,000.
So the amounts became due at different times, so that we're asking for the same interest rate to apply to all amounts, but the time period is different.
Oh yeah, no, not the interest rate, but that the calculation will run from different dates.
Yes, Your Honor.
Yeah. Okay.
And so the first calculation on the number the court just referenced, $309,664.04, was due April 12th, 2024. And so as of this morning, I have calculated that interest as being $78,963.68. Then the smaller amount of principal, $36,809.52, was due May 21st, 2024. And as of this morning, based on the commercial account interest rate, $8,834.29 is owed on that amount. And then I can state in my place, or I can be placed under oath. I've submitted an affidavit and would state here that the reasonable attorney's fees actually incurred in this case are $17,414.47. And then there was approximately 2 hours of time to prepare for and attend this hearing. I've submitted an affidavit which outlines my scope of practice, that's my standard hourly billing rate, and that my opinion is that is fair and reasonable, and that those were the expenses that were necessary and actually incurred as a result of defendant Deep South grading and construction's actions, in this case, including that they were behaving and being stubbornly litigious, acting in bad faith, and causing Northwest Georgia Paving unnecessary trouble and expense. So the total judgment amount that Northwest Georgia Paving is requesting is $452,436. Because, as the court referenced, there are other matters, or there are other claims still in this case, we would ask the court to make this a final judgment pursuant to OCGA 9-11-54B.
And again, this would be a judgment solely as to Deep South grading. Your view is that Mr. Wilson is still in play because he did answer, and you're just going forward with discovery?
Yes, Your Honor, and that I did. Mr. Wilson has failed to respond to discovery. We have a pending motion to compel and for sanctions filed. It was filed less than 30 days ago, but I don't know if the court has direction or guidance. Should we submit a proposed order after the expiration of 30 days, or do we need to schedule a hearing on that?
So, and this may have already happened. I apologize for not remembering, but the way I have things work in my division is if there is a discovery dispute, the first thing we do is get on the phone with everyone and talk through what the hangup is. Did we have that kind of teleconference or in-person event with you and either Mr. Wilson or a representative of Mr. Wilson?
We communicated with the court in compliance with the court's standing order and requested and received permission to file the motion before we filed it, but we have not had any informal conference with the court.
As long as you did what you just described, that's fine. The standard path would be to have a teleconference, but sometimes we skip that if someone reaches out to say, here's why we'd like to file this motion because of A, B, C, and D. So if you got that green light, then it looks like we need to wait another 10 days or so. And if you would, let me see. So it was a motion to compel discovery from both Deep South and Mr. Wilson. Deep South is now in default, so I don't know what kind of relief you want to get from them, but it would be helpful if you would submit a proposed order that maps out the relief you think you're entitled to as to Mr. Wilson and as to Deep South if you think there's relief to be had there.
Well, yes, sir.
Okay. And then we'll at least wait for the full 30 days just in case there's going to be a response. But if we've got that proposed order in hand, then we can turn to that after the time has passed. Anything else, Mr. Snyder, on behalf of your client?
Nothing on behalf of Northwest Georgia Paving.
Mr. Lee, I know you are tangentially connected to what we're doing right now through your client, Plainville DG. Anything you want to add, or are you just keeping tabs on what's happening?
No, sir. I mean, we're about to have to get busy on my end of the case. For planning purposes, does Your Honor have a require mediation for all cases? Because I would like to request I think this case would be good for mediation, at least between my client and Mr. Snyder's client. We've talked about it, but his client has been looking for a more global settlement with everybody, but I don't know the realities of getting Mr. Wilson or his company there. We've been talking to him, and I don't know how much he could pay that would satisfy Mr. Snyder, but we would like to run it settlement before we had to go the distance on this one.
Right. So I'm looking but not seeing. Usually I enter a scheduling order. I don't know why we didn't do that here, because I know we've all spoken before. That's how I remembered this cross claims and whatnot, but it may have been we were waiting to see who was going to plug in for Deep South and no one did. The answer to your question is I do not by default mandate mediation. We would have talked about it at the scheduling conference, which maybe we didn't have because, again, I'm not seeing a scheduling order in here. I am open to hearing from Mr. Snyder about it. And if he says he's not opposed to it, then we could agree on a deadline by which mediation ought to happen in the case. But either way, I need to get some deadlines in place. So we've got a trial date and a deadline for final dispositive motions.
Your Honor, we're not opposed to it at all and would support it so long as the order requires everyone to be present and that we would potentially, obviously, be able to raise an issue of contempt if Mr. Wilson didn't come. But no, we agree and would support an order that required all the parties to attend mediation.
He says I have not been speaking with him, Your Honor, but my client has, and he says he will attend. He's up in North Carolina. It may be over Zoom, but we've expressed to him that Mr. Snyder is not going to go away, no matter how much he ignores him. And it's in his interest, to participate. And he has said he would. Now, I don't know what he's got to bring to the table, but that's better than him saying, no, I won't participate.
Yeah. Give me 1 second. So, well, let's talk scheduling then. We are in early September. What is a reasonable deadline for mediation? And it would be for all parties. Mr. Snyder, I'll start with you. You want to say end of October? Is that too soon? You've got these depositions lined up.
I guess maybe that's not too soon for me. Or the issue is I have had very difficult time communicating with Mr. Wilson, and so but I guess I don't know if Mr. Lee that's not too soon for us.
Well, I can order mediation, and if he doesn't show up, that's a whole nother set of consequences. But I don't want to hold off on scheduling something because a recalcitrant defendant is playing hard to get.
The only issue with October is not too soon for me, nor my client. It's just that a lot of mediators, they kind of booked up is the only issue.
Okay.
I'm happy to
say
get it done as soon as possible, but I also know that a good mediator right now is, at least I can't ever find one in a month.
So do you want to say by Thanksgiving?
Yeah, that'd be, I mean, if we can't get it by then, we're not going to get it, Your Honor, in my opinion.
Okay. So what I'll do is a scheduling order that must mediate by, looks like Thanksgiving is, so we'll say by November 24th, mediate 24 September. And in terms of discovery, we never really set a deadline. 6 months probably has run, but
I'm making my people available with that regardless, Your Honor. So it's
okay. If
we got them scheduled and we're making them available without even a non-party, we're making them available without a subpoena. So I'm not planning on changing my position on that. But if Your Honor wants to formalize it, I know that Mr. Snyder has been having some difficulties with discovery with the other parties. So he may want the court's compulsory powers to remain in place longer. I don't know.
Right. Mr. Snyder, if we just had discovery end at the end of the year, is that enough time or you don't need that much time?
No, I think I do need that much time. And I would say we're not outside the 6 months because we added Mr. Wilson late. So he just filed an answer within the last 6 months. But no, I think if we can get this mediation scheduled, I mean, hopefully that resolves the whole thing. But if it doesn't, I mean, I think we're going to need a little bit more time just because, I mean, I haven't gotten a single document from Deep South or Mr. Wilson, and they are the primary holder of documents, I would think, on the defendant's side. But so, I mean, we got a pending motion to compel there. We got another 10 days before we get an order. I have no idea whether the defendants are going to comply with that order or whether we're going to be back before the court. So, I mean, I really would think like, the end of February probably.
Okay. 6 months from the answer would be actually before your mediation. The answer was filed on May 16th. So end of year is adding another month and a half to that period, but it's also end of year when times are a little zany. I don't know how much you think you're going to get out of these two defendants, but I appreciate your optimism. And I'm happy to say that discovery closes at the end of January. So end of January, and then I'll get a dispositive motion deadline and a trial date in that scheduling order as well that will flow from that closing of discovery. And these dates can always change if something shifts around and all of a sudden Deep South gives you 8 terabytes of data and that's at the end of January. We can move things, but I do want to impose some structure on this that hadn't been because we were trying to get all these other parties officially in the case. And then there was that May answer. So the mediation deadline in this scheduling order, and it'll be mandatory mediation, will be November 24th. Discovery will close at the end of January, and then I'll add a dispositive motion deadline and a trial date. Does that work for you, Mr. Snyder?
Yes, Your Honor.
Okay, Mr. Lee?
Yes, Your Honor.
All right, Mr. Snyder, anything else on behalf of Northwest Georgia Paving?
I'll submit a proposed order to Ms. Niles for the court's review on today's issue.
Great. And we'll get that in, assuming the numbers all add up, we'll get that entered. And we'll also get the scheduling order entered, and that ought to move things along. If you can also get that proposed order, assuming, and we'll see how it plays out, that you don't hear back on the motion to compel discovery, that would be helpful.
Yes, Your Honor.
All right, Mr. Lee, anything else?
No, Your Honor.
I'm glad you figured out the technology. Thank you guys for joining.
Thank you.
Bye-bye. Okay. Next is Shaquinus Ray versus Rashelle Lough and Healthy Eats Vegetarian Cafe. Good morning. Are you Ms. Ray?
Yes, sir. What?
All right, come on up to the podium right there, please. And let's see, doesn't look like there's anyone on the Zoom call for that. So Ms. Ray, as I understand, how do you pronounce the name of the other person involved?
Racheline
The last name?
Low.
Low. All right. So Ms. Ray and Ms. Low. You and Ms. Low went into business together. You invested $10,000 with her to create the Healthy Eats Cafe or to invest in it.
Yes, sir.
And nothing happened with your money, or something happened with it, but it didn't result in you getting any profits from the business. You weren't able to get your money back. And so you're out $10,000.
It's actually more than 10,000.
Well, let's talk about that.
I summed it up to probably about 15,000. The 10,000 was an initial investment, just basically to move the restaurant from Virginia, Newport News, Virginia, back down here to Atlanta, Georgia.
And this was a restaurant that Ms. Lowe already had, or you and she already had?
That she had already had.
And she said, hey, I'd love to have a business partner. Would you be my business partner?
Yeah, basically.
Okay.
I was introduced to her through my mother-in-law. My husband, he's still up in Virginia right now on business, but yes, I was initially introduced to her through my mother-in-law, and she basically said, she had looked into a restaurant down here in Atlanta, Georgia, where I'm initially from. And
so did you come down here from Virginia for the trial today? Home for you is Virginia?
No, home. I moved back to Atlanta, Georgia because of the business.
Oh, okay.
Yeah. So with the 10,000 that I initially gave her, it was supposed to be like a down payment for the restaurant, which is basically, it was brought to my attention that it's not a restaurant, it's actually a ghost kitchen.
Okay.
I don't know if you've heard of those, but they're basically, it's like in this one big building, a bunch of restaurants, and you just go in, place takeout orders, and
I can't sit down there, but I could show up, or Uber Eats would deliver it to me. I go online and say, I want Healthy Eats vegetarian burger, and DoorDash delivers it.
Yes.
Okay.
Yeah, so that was brought to my attention later on after I had already given her the 10,000. But besides that, we were back and forth from Virginia to Atlanta, Georgia for probably about 2.5 weeks just to look at the space and, to get everything situated as far as like, utility costs and, what's what basically. And within that, just with gas fare, I was covering that alone. Getting Airbnb, she didn't, give me anything, to help me with that. It was basically like I was just covering everything on my own. When we got down here to Atlanta, just officially, I went out and purchased just food for the restaurant itself, just multiple things, with appliances and things of that nature. So yeah, when I found an attorney to help me with the situation, he was just like, because it wasn't more than 20,000, then I could only get back like a percentage of it. So here I am.
Okay. So I'm looking at your complaint. So have you contacted Ms. Lowe to ask for money back, or for what's the nature of your communications
I
now?
tried to contact her prior to me, deciding to, withdraw back from the business, but I had no luck at all. And right now she's still currently in business in the same location, that initially was supposed to be ours together.
Right.
But yeah, I haven't had any luck with reaching out to her. Well, with trying to communicate with her at all.
So I could get food from Healthy Eats now.
Yes, sir.
but you're not getting any benefit from the investment you
Not
made.
at all.
Okay.
Not at all. When I tried to reach out to her, I just basically, because I had like the login information, for the business, like any type of account that was set up between me and her, and I had like, she basically blocked me from being able to access anything when it comes to the business itself.
Okay. Give me 1 second.
I forgot to mention, I did as well, purchase like permits and stuff like that for the business as well.
Okay. So, the way the posture we're in now legally is that you filed your complaint. Ms. Lowe didn't answer and the company didn't answer.
Okay.
So they're in default, which means everything that you have alleged in your complaint, I treat as being true.
Yes, sir.
So you invested $10,000, you were supposed to get profits, et cetera.
Yes.
You've shared with me some other costs that you've incurred.
Yes.
They aren't explicitly spelled out in here, so they're not dollar amounts.
Okay.
So the way today is going to work is, at a minimum, I'll enter a judgment in your favor for the $10,000 plus interest.
Okay.
But if there are other items for which you think you ought to get a judgment against Ms. Lowe, you need to have some proof. Like, here's a receipt of this. You mentioned permits, for example.
Yeah, well, my lawyer, he was supposed to handle all of that, so I'm not sure, well, he told me that he didn't have to be here today, so that's why I'm here alone.
Okay. That's news to me that you have a lawyer. You filed the complaint. It was a pro se complaint, so.
He handled, well, he handled like all of the documents and stuff like that, and I just basically came down here and filed them.
Okay,
myself.
got it. Because you filed it, you are what we would call counsel of record. You're representing yourself.
I had no knowledge of that.
That's okay. And there's nothing wrine with you representing yourself.
Okay.
But there's no lawyer in the mix. And more importantly, your lawyer is not here right now. He or she would be fine if that person showed up today to say, hey, I'm actually Ms. Ray's lawyer, and here's this evidence and that evidence. But that person's not here. So
The 10,000 is news to me. It was supposed to be, I think, about 13,000 and some change.
yeah,
So yeah, the 10,000 just alone is news to me.
when you say the 10,000, I thought that's not what you invested.
No.
Okay, well, the complaint that you signed says that you made a $10,000 contribution
Okay.
to Healthy Eats. And so that was sort of the partnership. It says you contributed 10,000 for your ownership share, and that's
all.
well, I'm not gonna say that's all, but that's what's in the complaint.
Okay. Yeah.
There's not.
I gave him like receipts, like as far as like, with the with everything that needed to be done as far as like, I can't think of it. With the, I guess as far as like, her being able to actually be in the business, I submitted all of that to him.
Yeah.
Everything from receipts to text messages to a voicemail of, my last encounter with her, like everything. But I think the problem is because it was brought to my attention that I filed incorrectly when I first filed this notion. And I had to go back and refile everything. So I guess in the midst of that happening, everything that I initially, gave to my lawyer, the person that was supposed to be helping me with the case, I guess got pushed to the side. Basically.
Okay. Could be. I'm just looking at what's in the docket, and there's your lawsuit, and then the sheriff served Ms. Lowe.
Okay.
And then some time passed. I entered an order saying, hey, the defendants are in default. So, Ms. Ray, you need to figure out what you want to do. So you then filed a motion for default. And again, that was filed by you. A lawyer may have helped you write it, but it's filed by you.
I understand.
So where I'm limited to what's in your pleading.
I understand.
And your pleading said $10,000.
That I know that I would have bought everything with me here today.
Right. So if you want to reset this, we can do it again. I can move your case to the next default calendar, and
Okay.
you could bring evidence that addresses those other things. But the bulk of it, the 10,000, you're entitled to because Ms. Lowe is in default.
Yes, okay.
So what's your preference? You want to go forward today, or you'd like to reset this and either your lawyer will show up with you? That's not necessary, but at a minimum, you'd be back and you'd have the evidence that you think would help support anything beyond the 10,000 plus interest.
Honestly, I'm just about completely over.
Done with all this?
Yeah, so I'll just take, the 10,000 plus the interest, whatever it is that you feel like I deserve.
Okay. Well, I want to be clear. You probably deserve a whole lot more for the frustration and agitation. And it sounds like you spent additional money to support Ms. Lowe in this venture, and you got nothing for it. You basically, how'd you know her?
Like I said, I was introduced to her through my mother-in-law.
Oh, that's right. That's right. Thanks, mother-in-law.
Exactly.
I'm happy to go forward with a default judgment that is based on your complaint, which is the 10,000 plus interest. Now, and you heard me say it to some other folks earlier, it's not like, I guess it was Ms. Huntley who was victimized in that other case. It's not going to be a check for $10,000. It's a judgment, and you'll want to talk with a lawyer about how you collect on that judgment.
Okay.
It creates a legal obligation for Ms. Lowe and the company to pay you back the 10,000 plus interest. Interest is going to be a fair amount of money. So that's what a lawyer could use to put liens on things or garnish or whatnot.
I understand.
But it sounds like that's how you'd like to go forward?
Yes, that's fine.
Okay. Do you have questions about anything else?
No, I don't. I'll just reach out to the person that was helping me with the situation, and I'll just go from there.
Okay. All right. Ms. Niles, anything else with Ms. Ray? No? All right. So that's the plan. You were here. There's a default. I'll get the order entered, which is basically a judgment.
Okay.
You've been doing e-filing, so you get things electronically? Good. So that order will be entered. You'll get an electronic notification, and then you can, like you said, just get with that lawyer who's been assisting you.
Yes.
Say, where do we go from here? And hopefully that person gives you good advice.
Thank you so much.
You're very welcome. Thank you for being here.
Bye-bye.
Bye. All right, we're going to do Heights at Grant Park versus Karambisi in 1 second. Who's on for that? No one. Well, that'll be a quick one. Need 1 second. All right, last call on that. Had you heard anything from Ms. Taylor on that? Okay. Oh, you can dismiss that. So that gets us to our final case, which is LGE Community Credit Union versus Health and Style Institute. Who do we have for LGE?
Judge Molly Gray for LG.
Can you say your last name again?
Gray, Gray.
Gray. All right. And that's who we've got the court reporter for. We've got another lawyer, but Health and Style Institute is in default.
That's correct. Good morning, Your Honor. John Rezak. I represent defendant Joshua Taves.
Okay. And you are here just to see how this goes?
We did file a limited objection, and I can talk about that now or when the court prefers, but we did have some concerns about what judgment is ultimately entered.
Okay. So what I'll do is let Ms. Gray go forward, and when she's done, Mr. Rezak, I'll certainly hear from you about your client's concerns, and we'll figure out how to weave them into whatever the judgment against Health and Style Institute looks like.
Thank you, Your Honor.
You bet. Just getting the docket up here. Whoops. Okay, I'm ready for you, Ms. Gray.
All right. Our LGE Community Credit Union is moving for a default judgment against Health and Style Institute LLC. I understand that Mr. Taves' counsel filed an opposition to that, in which he was concerned that we had inadvertently, through a typo, also moved against his client, who has timely answered. I know that Mr. McMahon in your status conference confirmed that we were not seeking default judgment against Mr. Taves, and I will state the same today. We are only seeking a judgment, a default judgment against Health and Style Institute. Based on that, I'm going to go ahead and object to any opposition from Mr. Taves and his counsel, as they don't have standing to oppose this motion.
Okay. Well, I'm going to give him observer status for now. We'll see what you have to share, and then I'll see what Mr. Rezak has to share.
Okay.
All right.
The complaint against both parties was filed on March 14th. Health and Style Institute was served via its registered agent in Delaware on April 1st, and to this date, it has failed to file a timely answer. I have from LGE Community Credit Union, Ms. Lisa Lawrence on Zoom to provide testimony about LGE Community Credit Union's damages.
Okay. You want to swear her in?
Hi, Ms. Lawrence.
Good morning.
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. What is your position with LGE Community Credit Union?
I'm a commercial lender.
And are you authorized to give testimony on its behalf?
I am.
All right, I'm going to first look at the business loan agreement marked Exhibit A for the principal amount $1,600,000. Did LGE enter into this agreement with Health and Style Institute LLC?
Yes, we did.
Okay. And as of the date of this hearing, what is the principal balance on this loan?
The principal balance is $668,985.71.
And is this reflected in what is right now our unmarked exhibit, but I'll mark Exhibit B from LGE Community Credit Union? I have a payoff letter.
So before you call that B, I have A, B, and C already from your exhibits. Exhibit B is second agreement and Exhibit C is first payment history. Were you going to be using those, or?
I'm using a couple of those. Would you mind if I renumber them?
You can do whatever you want. There's something on my screen that says Exhibit B. That's probably not what you were about to call B.
Okay.
So just so you know,
I emailed these two further exhibits to Ms. Niles on Friday. Do you have those? They're just two payoff letters.
I do. They just don't have, there's payoff letter 1006 and 9001. They don't have exhibit letters attached to them.
They do not. I'm going to label 9001 Exhibit B.
Exhibit B. Got it. Okay.
All right, Ms. Lawrence, again, what was the principal amount for that loan?
The principal balance is $668,985.71.
And what is the accrued interest as of today?
$12,204.35.
And are there any late fees for this balance?
Yes, $3,499.74.
What is the total owed under loan 9001?
Total as of today is $684,689.80.
I'm now going to look at what has already been marked Exhibit C, and will maintain Exhibit C, which is another business loan agreement for principal amount $500,000. Did LGE Community Credit Union enter into this loan agreement with Health and Style Institute?
Yes.
And what is the current principal balance on this loan?
$500,000.
Okay. And I'm looking at loan payoff letter for loan 1006. I will mark as Exhibit D. What is the accrued interest to date for this loan?
$25,666.67.
And are there any late fees on this loan?
Yes, $1,036.98.
And what is the total payoff amount for this loan as of today?
$526,703.65.
Thank you, Ms. Lawrence. LGE Community Credit Union is also moving for its fees under 13111. Under 13111, subsection B does not apply because this is a default judgment. So the statutory amount of fees based on the amount outstanding is $121,139.35.
When you say, I don't know all the paragraphs of 13111, what's B?
Subsection B is the section that allows a defendant to contest fees for reasonableness if they're over $20,000.
Okay. What about a judge thinking whether it's reasonable or not? I have no doubt you and your firm have done great work. I also have no doubt that you haven't done $121,000 worth of work.
You would be correct, Judge, and I am ready to give testimony on our actual fees accrued today.
Okay. There was one other exhibit. It was payment history. I assume with your witness testifying, you don't need that.
correct, Judge. I didn't have these current payoff letters, so it showed a payment that had been made on the day that we filed, so was not reflected in our motion. Okay.
Do you want to admit for purposes of this default judgment hearing as to Health and Style Institute only, the 2 payoff letters and the 2 loan agreements?
Yes, Judge, and I believe that Mr. Razak has stipulated to, he's definitely stipulated to the business loan agreements. I'm not sure if I received confirmation that he stipulated to the payoff letters, but yes, I would like to move to admit.
Okay, well, and to your point, I don't know that he has grounds to object to them coming in this hearing, but it's good to know that he's seen them and is okay. So they're admitted, the 4 are admitted. And then why don't we talk about fees?
All right. I did not submit fee exhibits to the court, but I do have them here today. To date, between fees and expenses, LGE Community Credit Union has incurred $39,801.34. And I am a 4th-year attorney. I was barred in 2022, practicing exclusively in commercial litigation, creditors' rights, and real estate litigation. My rate is $400 an hour, which is customary for this practice area in the Atlanta metro area. And I did a significant amount of the work on this case, as well as senior attorneys who bill at $500 an hour or $550 an hour, $550 an hour, and paralegals who bill at $275 an hour. And I graduated from Vanderbilt University in 2022 and was barred directly after.
All right. So do you have an exhibit that maps out the fees?
Yes, Judge. I have 2 exhibits that I can submit to the court. They are unmarked.
Okay.
But would you like these paper copies or emailed copies at the conclusion of this?
Why don't you email? That'll just be easier. So when we're done here, you can email what would be, I guess, you already have 4 in, so Exhibit E and F, if they're 2 separate things, that would be helpful. So the total judgment, I'm looking at, well, you may have more you want to say about, that's it?
That is.
Okay. Oh, and now I understand why, because the counts 1 and 2 are the only counts in the complaint against Health and Style Institute. There are additional allegations, but they're against Mr. Taves only.
Yes, and then Mr. Taves has since brought up counterclaims as well.
Yeah,
So.
and there's a motion for judgment on the pleadings, but it's all counts that are Taves only, and we'll work through those. Okay. Then if you could, if you haven't already, send to Ms. Niles in Word format a proposed judgment that has those dollar amounts, and then the number I would put in for attorney's fees is what's been actually billed. And then if you'd also include in that email the 2 exhibits, E and F, that would be great. Let me see if there is anything I need to hear from Mr. Razak.
Good morning, Your Honor. John Rezak again for Joshua Taves, defendant, and Mr. Taves is present via Zoom. Your Honor, if it is clear that this judgment and the evidence supporting this judgment will not be prejudicial to Mr. Taves in any way, then I would agree with counsel that there's nothing for us to add. However, if this evidence is going to be used as presented today, we would want to argue about the plaintiff's entitlement to fees under 13-111 because we don't believe the proper notice was given for those statutory fees. And I would also have some questions about the application of payments to the two loans. So that's where we are, and happy to take the court's guidance on that.
Okay. My response to that would be, I don't see how the award of attorney's fees against the defaulted defendant would be relevant in any way in the future if this goes to trial with the remaining parties. I could see how it could be relevant if a jury is needing to decide things like a 13-6-11 factor or who knows what, that the LGE might want to present to the jury the fact that there is a default judgment against Health and Style Institute. So writ large, could the fact that Health and Style went into default and had a judgment entered against them, they may want to get into that. They may want it to stay out because the jury might think, then why are we bothering Mr. Taves? There's a judgment already. LGE should go home and collect on that. So I'm not deciding today whether a motion in limine would exclude the fact of a default judgment against LGE, but the attorney's fees piece of it to me seems like if for some reason that's what LGE wanted to focus on, hey, you need to award attorney's fees against Mr. Taves because there was already an award of attorney's fees against his former corporation. I don't see that being a valid argument, and I don't think that would be relevant. So I think that's where I come down in responding to your concerns. But if you want to, Mr. Rizak, probe a little bit more, I don't want you to leave here wondering, well, how would this play out if in the end there's a jury trial between LGE and your client?
No, thank you, Your Honor. I think the court has addressed our concerns, and so with that and with counsel's presentation, I think we are fine. So thank you.
Sure, and I'll reemphasize, although I think Ms. Gray made it clear, the inadvertent S on defendant does not mean that the default judgment that I intend to enter against Health and Style Institute is in any way, shape, or form a judgment against Mr. Taves. That litigation continues, and we need to talk a little bit. I don't know if there's a scheduling order in place or what, but we do need to put some structure around what remains with this civil case. So just to close the loop on Health and Style Institute, Ms. Gray, you'll submit a proposed order as for that judgment with the dollar amounts, and you'll get us the 2 exhibits that relate to attorney's fees as to Health and Style Institute. Turning back to the docket, there is a scheduling order. I entered it just barely a month ago, and it says we're done with Health and Style Institute. It has today's date on it for the default hearing. We did that. Discovery runs through early January. Dispositive motions are due mid-January, and you've got a trial date. So I'm assuming those dates are still good for plaintiff?
Yes, Judge.
Okay, and Mr. Rizak, for you?
Yes, Your Honor.
Okay, and again, things could change and get in the midst of the holidays. We may need to adjust something, but let's try to hew to those deadlines. And in terms of what is pending, there is a motion for judgment on the pleadings as to count 4, and there is a motion for an order dissolving what is described as an improper lis pendens. Those are not yet ripe. Your responses aren't due for a couple more weeks. Are those things you've already noodled and know, hey, you know what, count 4, you can dismiss, or you guys will be filing opposition to both those?
I believe we will be filing opposition to both of those.
Okay. Then I'll take up those issues. Are those in any way interfering with discovery on plaintiff's side?
No, Judge, we have both exchanged written discovery and responded to it.
All right, Mr. Rizak, you're good to go with discovery thus far?
Yes, Your Honor.
Okay, then when your 2 motions are ripe, I will rule on those, and we'll see where those take us. If anything urgent comes up, do reach out to Ms. Niles so we can help keep you all on schedule with the deadlines that were set. Ms. Gray, anything else on behalf of LGE?
No, Judge.
All right, Mr. Rezac, anything on behalf of Mr. Taves?
No, thank you, Your Honor.
Okay. Ms. Gray, it sounds like you're the one who requested the court reporter who's been taking all this down. You will settle up with him, or did you and Mr. Rezac agree to split?
Yes, we agreed to split.
Okay. Well, both of you settle up with the court reporter. If there is nothing else, you all are free to go. Appreciate your
Thank
time.
you, Your Honor.
Thank you.
All right. Bye-bye.
Thank you.